Okay, so we were here last time on January 28th. I'm reading my system. There's a case in front of Judge Anderson. It was scheduled for March 13th, scheduling conference. There's been no payments made to escrow from May 2025 to August 2025. And there's a total of $5,740. So where do we stand?
Yeah, I'm going to let my client, Alexandra Riley, address the court with regards to escrow.
Thank you, Attorney Fair. Your Honor, I did want to reference that. And first, I want to apologize. I believe I was supposed to appear in person. I'm with someone, we caught a flat tire, so we're waiting on AAA now. So I apologize to the court for that first. Secondly, the duration of this court is, this proceeding, as the court knows, there is a parallel case before the circuit court with regard to the ownership of the home. Attorney Fair does not represent me in that proceeding. Another attorney will be engaged on that forthcoming. Based on the merits of that case, Your Honor, and based on the complaint and the pleadings that are being made within that, it was my understanding that a stay of proceedings based on the bond would not necessarily or could retroactively not be imposed. And so what I mean by that is there's been a substantial investment. I'm the homeowner, I'm not a tenant. There's been a substantial investment and costs being incurred over the course of the duration of this case. There's also been conditions that have changed, be it the case has advanced in circuit court prior to the bond being issued at the lower court within this court, Your Honor. So I'm asking, and I believe if we need to file a motion for it, I'm asking that we, based on it being premature, given the disputed amounts, I'm asking that we allow for, with the discretion of the court being reasonable and with the consideration of the changes and the advancements in the circuit court case, that we set aside or adjust or allow for a personal bond for the duration of the circuit court case.
Mr. Gray?
Yes, Your Honor. So I do understand that changes in circumstances certainly do happen and they can justify certain decisions made by the court, but I don't think this is a circumstance that does. The whole point of these escrow payments is so that this money is out there so that at the end of the case, whoever needs to be paid that payment gets the money. There's been multiple orders by this court, I think 3 or 4 at this time, asking for the escrow to be brought current, make some kind of payment. None of them have been complied with. And to the extent that the circuit court, however the circuit court handles their case, does not impact the escrow here. Again, this is something that was ordered by this court. I think it's been 10 or 11 months now of missed payments. There's been no attempts to make a payment since April of last year, so I don't know that there's much else beyond that, Your Honor. It's simply just not been complied with.
Yeah, yeah, if I may, yeah. If I can somewhat re-articulate Ms. Riley's argument, which is, number one, this is a home foreclosure and not a landlord-tenant. She has owned the home for some time, and she believes that she has a meritorious case in the circuit court. Whether she does or does not, I don't know. I would say it is sort of unusual that the matter keeps being adjourned in circuit court. That is what I would say an indication, because if it wasn't a strong case, the circuit courts normally would just, as quickly as they can, dispose of the case by way of the motion of summary disposition. So I think the point she's making is that assuming that she doesn't get to keep the house, that she has made a substantial investment in the house, and that a substantial investment should cover any bond or escrow payments. Now, with regards to the court order, and why she hasn't made any payments other than these legal arguments, I will defer to my client as to why she has not been able to make the payments. And I think she'll do a lot better job than I could to articulate her position on why on a monthly basis she has not been able to make the escrow payments.
Okay, because so April 2025, there was a $640 payment. October 2025, there was a $640 payment. So there's $1,280 in escrow.
Your Honor, if I may, I don't want to interrupt. There was only one escrow payment. That one in
Okay.
October, if you may recall, there was kind of a weird situation here. There's only been one payment, just the April one.
So it was paid out to you. It's a trust payment check.
Yeah, it went to us for some odd reason. Then we did send it back, but there hasn't been two payments. That October one just like for whatever reason was distributed out. But there's only been one payment in April.
Okay. All right. So obviously home foreclosure. If you lose, the house gets taken back to the bank. But there's still it's still a mortgage amount, correct? How much is left on the mortgage? It's a home foreclosure.
Let me pull that up. I don't have that right here, Your Honor.
But while you're figuring it out, yeah, Ms. Riley, there was an order for these payments to be made. Obviously, you're not, depending on a case in circuit court and what happens, we don't know where the payment's gonna go. They may go back to you, or they may go forward to the plaintiff in this matter, but there is an order for payments to be made. Was there a September payment made? I don't remember. I don't have anything in my notes about September.
No, Your Honor. As far as I'm aware, no payments since April.
I don't know if Ms. Riley has a different opinion or not, but this is her opportunity to speak on how many payments she has made.
And thank you, Attorney Fair. May I proceed, Your Honor?
You may.
Okay, thanks. With respect to the payments being made, this is a case before the circuit court whereby ownership is being contested, where there's violations from HOPA to RESPA to TILA. There was over in excess of $24,000 in escrow. In addition to that, there was another $25,000 that payment that was made to the bank. The bank would not be irreparably harmed if occupancy or was granted or possession was granted to the bank. They're a vast organization or financial institution. In contrary, I would be irreparably harmed with respect to possession being granted to them, and also in the pursuit of the justice on this case being awarded to me, which I believe, and with respect to what Attorney Fair indicated, as he thought my intention was the merits of the case. It has proceeded. That is a difference based on prior to this matter first appearing before this court, upon us filing the circuit court case, upon it advancing within the circuit court, and upon the fact that we believe that we will be victorious in that. And there's also been a lot of expense that has been incurred as far as paying court costs, attorney fees, and things of that nature. And so that's why I'm humbly asking the court to revisit that. I believe the court has discretion to do that in the interest of justice when it is a reasonable request being made, and also to apply it retroactively to allow for me to either waive the bond or apply a personal bond while the circuit court case continues ongoing.
All right. So let me see. So May 2025. That's what I'll do. Did you get that number, Mr. Gray?
I can't seem to find it, Your Honor, but I mean, I don't know that it's necessarily important as of today, just because I don't know that how much she's paid toward the property really has any impact here. We foreclosed on the home. plaintiff purchased this property and she doesn't have a right to this property. I know there's certain circumstances that the circuit court may handle with that stuff, but we're not seeking any kind of money judgment through this. We're seeking a judgment of possession. And I know the court's not particularly interested in proceeding until the circuit court action is resolved, but I think just simply in terms of the escrow order today, these payments haven't been made. So however the court wants to handle it, I think is what's relevant today. I can get the court the exact number if there is anything, but we're not seeking a money judgment at this time.
So to date is 7,040. So I think that'll be the bond, 7,040. Do we know when that case is going to end? Like, when is
I
that
think the
case? It
last
seems like keep getting kicked down the road, and it's like it's holding up other dockets, you know.
right, I believe the last update, and Ms. Riley, if you have a different update, certainly please speak up. The last update I had was that there was a motion for summary disposition, which was supposed to be heard on December 12th. The court informed the parties that it would be reaching a decision without oral argument, and the court is just not proceeded with giving that yet. I mean, it's kind of just they've been sitting on it as far as I'm aware.
That's inaccurate. We had a hearing for scheduling order to move the trial.
Because I see something March 13th, 2026 is a court date coming up. I think that's what I noted in my notes when I looked back in January.
Correct.
Okay.
Miss Riley, what is that for? Do you know?
Just
Scheduling
Just a scheduling conference. Okay. But the motion they haven't decided the motion as far as you're aware?
I believe it was denied.
Okay.
You said it was denied?
I believe so, yes.
So I guess we'll set this out. Second.
Well, Your Honor, if I may, if the motion was denied, and I don't know if that is the case or not, but if it was denied, that does put things in a different posture because that indicates that there is a question with ownership and that a motion for summary disposition that doesn't require a trial was not viable with regards to the bank. So there is some issues out there. So that is a stronger case of why she has a meritorious defense in the circuit court.
Your Honor, I don't think that's relevant to the issue of escrow payments, though. It certainly might be relevant to the underlying case, but this is escrow payment doesn't really have anything to do with that.
Well, no. So from what I'm deducing, there's a financial hardship for the escrow payments to be made, and that's understandable. You know, I deal with people who, struggle. I know there's various levels of it, and Ms. Riley's spending a lot of money for, attorneys and court appearances, stuff like that. I'm just trying to make it to where whatever the final decision is, the money can be transferred to whichever party without there being a significant delay, right? So if it in fact does go back to Ms. Riley, if she wins at trial, obviously the house is hers, she gets her money back. But if the opposite is true, then I want to make sure there's money there that's forwarded to the plaintiffs in this matter. So I'm just trying to figure out, should I do a cash surety? Should I do a personal? What should I do to ensure that when a judgment on the merits is made, the money is transferred without delay? And so, and I don't even know how long this trial is going to be because I could order a $7,040 cash surety bond right now, and the trial goes on for another year, a year and a half or 2 years, and certainly 7,000 is not going to cover the remaining months. So I think I'll order a cash surety bond just in case. And then, so you won't have to post anything, I guess probably about the 10%, Ms. Riley, but it may increase as the case go on because of, unpaid quote unquote monthly payments. If it goes on to if it goes on to, July, we got to account for April, May, June. so it may increase, but I'll keep reviewing it every 90 days and see where the case is. And hopefully circuit court can move the ball at some point. So that's what I order. So a $7,040 cash surety bond. And we'll come back in 90 days. Hopefully we have an update. You know, I don't know. But if we don't have an update, we will increase the amount. So we'll give you a date. Takes us to June. And it'll be a pre-trial. June, we can do 3rd or 1st, Mr. Fair, Mr. Gray.
Yeah, either day works fine with me, Judge.
It'll be June 3rd.
June 3rd should be good for me as well.
And there'll be a pre-trial at 2 o'clock on Zoom. So I'm ordering a $7,040 cash surety bond in this matter. Okay. Is there anything else?
I have
Nothing from us, Your Honor.
All right. And are you resetting that March 13th date, Ms. Riley? I see it says early scheduling conference did not go forward, plan to retain counsel. Is your counsel going to that March 13th date in front of Judge Anderson?
That's in discussion now, yes.
Okay. All right. All right. So we're all set.
Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
Thanks, Your
Thank
Honor.
you. Yep, take care.